Everybody on the East Coast. This is Matt Feinberg. I'm the chair of the litigation dispute resolution practice at PilieroMazza. I'm here today with Cy Alba, who's a partner in our government contracts group, and Nichole Atallah, who's a partner and chair of the labor and employment group. We're here to talk and answer a bunch of questions about the ongoing pandemic related to COVID-19 or the coronavirus. For those of you who are already on the line, thank you for joining us. Some of you have been able to send questions in advance, and we have a list of those, and we'll try and touch on everything that you've sent so far. If you're just joining us or haven't had the opportunity to send any questions, you'll have the opportunity to do that. You can just use the webinar feature to send your questions directly to us. We'll try to get to all of those as well. We wanted to touch on a bunch of broad subjects to get as much information out into the public as possible. And we thought that was important because we've been following all of the publications by various groups around COVID-19, and the only constant is that there's a lot of conflicting information from what we have been able to see. And so we wanted to give this opportunity for clients, both near and far from Washington, D.C., to have a chance to ask questions, get information about what is an ongoing problem in the country, and hopefully get some clarity for their business and for how the next few months are going to go. So really quickly, let me introduce my colleagues. First, Cy Alba, do you want to say a couple words, introduce yourself?
No words necessary.
No words necessary. No. Hey, yeah, this is Cy. I'm a partner at our government contracts group. Thanks for everybody for coming. And I know we have a lot of government contracting questions dealing with defaults, delays, idle labor, DPAS, all kinds of stuff, hub zone issues. So we're going to go through all that stuff in due course.
And I'm Nichole. As Matt mentioned, I chair our labor and employment practice. And of course, at the heart of this is what's happening with our people. And so we're getting a lot of questions, not only about the impact of folks that are at home, forced to be at home, might get sick, but what the impact is on contracts because of the potential impact to our people.
So before we get into the questions and the topics for today, I do want to make everyone aware, this communication, this webinar in general, does not provide legal advice. We're not creating an attorney-client relationship. And with you or anyone else who's listening, if you require legal guidance on any specific situation, you should engage a qualified lawyer for that purpose. Prior results identified on the firm's website or discussed in this webinar are not necessarily indicative of a future outcome for you or for your business. So without further ado, I'm going to start handing it over a little bit to Nichole to talk a little bit about the questions that we've gotten about labor and employment recently. Specifically, there's been a number of questions that we've received about whether or not companies are required to provide safety measures or send people home from work. Why don't you touch a little bit on what an employer's obligations are when it comes to employees during this pandemic?
Yeah. So one of the quandaries that government contractors find themselves in is that, while the federal workforce may or may not be working from home, you all still have deliverables that you have to meet, you have requirements, and for some of you, the work just cannot be completed at home. And employees are starting to call saying, but I don't feel like it's safe to come to work. Everybody else is quarantining or self-quarantining, and yet I'm coming to the site every day. So we're getting questions about whether or not there's any liability to the company if you make someone work or if you make somebody travel. Right now, this is all being viewed under the lens that this is just like any other illness, right? We all need to take precautions during flu season. Of course, this is more severe than other illnesses and obviously having a large impact. But the answer is that yes, that these generally employees are employed at will. If they don't feel safe, they don't have to work. And I know that seems callous and cold, but the reality is that you still might need to have people there. OSHA has put out good guidance. They were very quick to put out good guidance about the obligations or what they would suggest employers do for safety measures. It's all the common sense stuff that you've been hearing about, folks. So I would encourage you to go to the OSHA website. We will put the resource out there for you as well. We'll link to it after the webinar. But it's a good way. I know a lot of clients have been sending that out to project managers and other folks. And that can inform and give them some good guidance as to, you know, hand washing, social distancing, things like that. I've also heard of different offices, you know, spreading out the shifts so they can create more space for people, taking those types of reasonable measures to keep people safe while they're at work. And we'll talk about the pending legislation for sick and family leave. That could also impact whether you can force somebody to be there if they have an at-risk situation. You might have some impacts from that legislation that's pending as well.
Okay. Well, just piggybacking off of that a little bit, I think we would generally recommend that if someone can telework, if someone can self isolate or at least practice social distancing at the employment site, we would recommend that that's something that each employer, to the extent you can do it, implement so that at the very least you don't give the impression that maybe you're ground zero for an infection or putting your employees at risk. The other thing I want to mention is that some states have more stringent laws than others. And so if you're in a particularly employee-friendly state like a California, maybe a Maryland or a DC, you're going to want to pay attention to your state-specific requirements. So and announcements, frankly, from mayors or governors about shutting down various businesses.
In fact, Bloomberg just announced this afternoon, I don't know the full details on it yet because I was listening to the press conference as I was coming in today, but they're going to a 50% required work with some limited exemption. So you can only have 50% of your workforce on site at any given time. Again, I don't know all the particulars to that, but that's one example, Matt, of states that are taking action to try to slow the spread.
Right. Well, so that's really on-site work. What about employers who have to send employees for travel internationally or within the United States, either on a government contract or maybe on a contract in the commercial sector, the private sector? Do you have any insights about what would be required there?
Sure. To the extent that the travel is still being permitted internationally, which is a concern, and we can, you know, Cy can jump in on the government contract side, but if you have a deliverable where someone has to travel to Europe or South America that's not letting Americans in, then, you know, that's going to be less of an employee issue and more of a, you know, obstacle to performance issue. But assuming that your employees can travel, that the travel is available, generally you can make employees travel. There are a lot of hazardous jobs out there. Again, you want to try to provide as many resources and warnings to your team as possible. But at the end of the day, if you don't have a choice but to meet that deliverable, you're going to have to ask somebody to go and just equip them with the resources they need to stay safe wherever they are.
Okay. Yeah, and from the perspective of like government contracts, you should definitely talk to the contracting officers on all your contracts and get out in front of things. If your employees are either refusing to travel or that the various, you're telling your employees, we don't want you to travel, but your contract requires it. Note DOD, I think at least DOD personnel, and I think it's going to go out to contractors if it hasn't already, has restricted all travel, including domestic travel. And that is also for permanent reassignments and for military personnel. So they're taking it pretty seriously, and it should trickle down if it hasn't already into your contracts. But note that if the government requires it as part of the contract and you're merely being prudent and frankly, like between friends, it's a smart thing to do to stay put. That doesn't excuse you from the contract automatically. The other thing to note is that if the government does something government-wide as the sovereign, as the government, and it's not particular to your contract, say shutting down travel outside of the United States. Let's say they just shut down airports and you can't get out. and that causes all kinds of other costs. So you still have to get there and you go on ship or something like that. Then that is going, or you have to hire a private plane, let's say. That's a better example. That cost is not necessarily recoverable because it was an act of the government as a sovereign, not the act of the government as a party to your contract. And that's just a special benefit that the government gets because it is the government. That being said, if you hear of something like that and it is going to directly impact you, if you can get the contracting officer to agree to that or to put something in your contract, either requiring you to do it anyway by any means necessary or something to that effect, that waives, or you have a good argument that it would waive the sovereign acts doctrine and allow you then to get additional costs under the changes clause. So that's a kind of key point. If there's broad measures that the government takes that you need to pay attention to. Also, generally, the state government actions, because we live in a federalist system, state actions don't necessarily forgive non-performance on federal contracts. So just be aware of that as well, and be speaking closely with the contracting officer.
And you'll hear a lot of what we say today is this is deep, this is specific to your situation. And it just is. Every single client we've talked to has very specific sets of facts that play into, whether a certain cost might be recoverable, what the disposition with employees looks like, whether you can let people work from home or not, what's the cost. And I know we received a question, and I've been getting a lot of these this week about network capabilities, because everybody is working remotely and it's straining the infrastructure that we have for everybody to work remotely. And so one of the questions was, it's affecting productivity because people can't access the firewall on the client site. And so we're experiencing basically deliverable lag, right? And so can we give people a bonus for meeting their deliverables and not necessarily pay them overtime if they have to work over 40 hours? Some of that's going to depend on whether your people are exempt salaried or non-exempt. But if they're non-exempt, whatever payment you give them, it doesn't necessarily have to be in what you would consider traditional overtime, but it has to be the equivalent of an overtime payment for any hours worked over 40, and employees have to know that they're, maybe it is that they're eligible for more than that time and a half rate, but somebody couldn't, if they're hourly, they can't work, 44 hours and just get paid for 40 because they still didn't meet their deliverables. That's for hourly employees. For exempt professional employees, you can do it that way. That's fine. Depending on the type of contract you have, you might have an uncompensated overtime issue with the contracting officer. That shouldn't be an issue on firm fixed price contracts, but other types of contracts, it can be. And if you have questions about uncompensated overtime, I'm not going to get into it here, but I'm happy to answer those questions if any of you have them. That does raise a question about telework as well. If you have hourly folks working telework, you should be carefully reiterating your overtime policies to them, because that's one risk. We live in a different world, but we need to find different ways to engage and keep our folks looped in and us looped in with what they're doing so that we don't end up with an overtime problem. All of your same policies can apply, but we need to make sure that we're reminding folks that if they're working over 40, it's overtime and they can't do it without letting you know first and getting approval.
Right. And as a litigator who handles a lot of overtime claims for companies that are alleged to not be paying overtime, I would encourage all employers out there to make sure that you are enforcing compliance policies about recording hours. If you have, say, a clock in or clock out system on your employees' laptops or computer systems, or have remote access, you'd be paying attention to that, and have, in my opinion, at least, have your employees sign off on the hours that they actually worked, because the last thing you want is to get past this entire pandemic situation and then have an employee come back later and say, well, I actually worked overtime while I was at home because that's what we needed to do. I wanted to make up for the employees who couldn't work. And you didn't necessarily have notice of it, or maybe you didn't have documentation to back up those overtime hours. We're not going to get into the nuances of the Fair Labor Standards Act or state wage and hour laws like Nichole said, but one thing that I say over and over is an ounce of prevention is worth a pound of cure, and really drilling down on compliance, particularly about wage and hour and leave time on the front end, will save you a lot of time and potential heartache on the back end. Before we jump into or segue into another topic, I want to answer a couple of questions that have come up that are more logistics. Yes, we are recording this webinar. You'll be able to access it from the PilieroMazza website and a number of other sources shortly after the webinar is concluded. There are not any slides other than what you have already seen on your screen. If you'll look at the bottom of the second page, you'll see that PilieroMazza is launching a client resource center related to the pandemic. You'll be able to see various documents there, including documents that give you links and contact information for various resources, the OSHA regulations that Nichole mentioned earlier, the bill that's going through the House and the Senate currently, and various other resources that we think are going to be helpful as you navigate this pandemic. So this is not the only time you're going to hear what we're saying. You can play this on the recording, and you'll also have the ability to ask us questions through email or through our website if questions come up after the webinar or in your specific operation of your daily business.
Can I say one thing about what Nichole was talking about? If you do have a cost reimbursable type contract, you got to really make sure that you're tracking hours and that your systems work and people can log into those hour tracking systems remotely if they are working remotely. And to Matt's point, another reason to have them sign off on that is just be crystal clear that they're certifying these hours are hours worked, because this is horrible, but I could see the government after this whole thing questioning certain hours or seeing DCAA, and no offense to anyone who works for DCAA or DCMA, but they are notorious for trying to get every penny out of contractors if they have an opportunity to do it, even where it's unreasonable. At least that's what I see.
Yeah, and it's a DCAA requirement that employees control their timesheets, employees properly record hours worked, they charge code admin hours. I mean, let's be honest, for those of us, with kids at home, it's challenging right now. So I think just reiterating that we understand you might have some non-standard things going on at home, but we all need to make sure we're honest with our time.
And actually, I have a question for you that's a side thing. Let's say someone is an hourly employee and they have to work way overtime, but they don't actually work all those hours. They take huge chunks off during the day and then work till 12 o'clock at night. But
they're supposed to be clocking out in the middle of it.
And it all adds up to 8 hours. That's still 8 hours, right? That's
still 8 hours. So they can be clocking in and clocking out throughout the whole day as needed.
All right, so that talks a little bit about the employment issues that come up that are related to the pandemic generally. But what about your employees who get sick or at risk, or they have family members who are sick? This probably touches a little bit on sick and family leave, but also HIPAA, workers' compensation, some other topics. Sure. So why don't we talk a little bit about that?
So let's take workers' comp just off the table real quick. This is not generally a workers' comp issue. This is not going to be a reportable illness, even if somebody thinks they got corona from somebody that's at work. In fact, half of the time, a lot of us have heard from employees that think they might be symptomatic, but chances are they may not have it. We just don't know. The testing isn't available or as widely available as we need it to be right now. So I think you will see more employees going out on sick leave, and it might be a good idea to talk about the sick and family leave that's pending. Mitch McConnell said that the Senate was going to largely pass sick and family leave expansion the way the revised House version was or is as of Monday. So they're currently contemplating that. We expect that they'll vote on it soon. It will not be the last. Basically, McConnell said today that the Senate is planning to pass it and then revisit whatever needs to happen, because it is an imperfect bill by all all measures because this is happening so quickly. But the crux of it is that all employers that are under 500 employees at this point would have to provide 80 hours of sick leave on top of what you already provide. So you can't double dip into what you have now. It's on top of what you already provide. And then part-time employees would be eligible for some estimated number based on what they're regularly scheduled to work. You would basically have to have COVID, care for a family member that has COVID, have kids that are out of school or their daycare is closed, or somebody has determined that you can't reasonably perform your job and you need to quarantine. You might be a high risk person that needs to be at home, and that would have to be done by a qualified healthcare professional. The bill takes into consideration that you're probably not going to be able to get to a doctor. So, you might not be able to get doctor's notes regarding the illness. We're all going to have to try to work through some of this together because I know a lot of employers are concerned about abuse. Employees immediately qualify for this, so just keep that in mind. And then employees will get up to $511 per day for the sick leave. So in total, that would be about $5,000 a person. And this would go through December 2020. So it's not an immediate, it's not like you have to use the 80 hours between the next 2 months and it's done. The sunset provision is in December of this year. This will be paid for by a payroll tax credit that goes out of basically the Social Security fund. So that's how you would get contractors would get paid back, is through a payroll tax. So you wouldn't necessarily get this through some REA or claim. This is a different bill and a different way to recover that cost. Obviously, you would be bearing that cost up front. So there's some concern that en masse, you're going to start to have employees go out sick once this becomes published. And we're just, again, it's not necessarily for everyone. So we're just going to have to manage as best as we can those requests and try to make sure that we're not running afoul of any of this particular law, assuming it's passed the way that it's currently laid out. Emergency family leave, it essentially amends the Family Medical Leave Act, but it would apply to employers less than 500 employees again, and any employer less than 50, which might be a fair number of you, could get an exemption from the FMLA extension if you can demonstrate that it would affect your business viability. And we don't know yet. The Secretary of Labor is supposed to put out regulations about this, but we don't know how lenient they're going to be about this. So, I think it's a pretty high standard. It is also limited to people that have to be at home taking care of their kids. But the first 2 weeks of that FMLA leave can be unpaid, or an employee could use PTO at their discretion. You don't get to choose, the employee gets to choose. And then the following 10 weeks of leave would be at 2/3 pay, up to $200 a day capped. And again, that would all be paid for out of a payroll tax credit on the back end. That doesn't always make you feel good on the front end if you're not getting, paid, or you have to hire additional resources. And so this was one question that came in on this. Well, what if I do have to hire additional resources because everybody is calling in sick? Can I get paid for that by the government? And I think that answer is no, generally.
The general answer is no, under the way the law has generally been construed. Now, who knows if this is somewhat of a different circumstance, if it is widespread in your organization. And the critical thing is, if you can actually prove that the individuals are out because of COVID-19 and without testing like we have right now, that could be a hard standard to prove down the line if people can't get tested and they're out. If people are out because of the flu, that doesn't count. Or if whatever else is happening. And if their kids are sick, or their kids have no school and they need to work from home, that's not the same thing as having the cause of your delay or other issue happen because of an epidemic. So just be aware of that. Now, the idea of money versus time, if you have a major delay to your work and you can show and prove that people actually have COVID-19 and it's widespread, that would give you a basis for an extension, a time extension, a delay claim. However, for costs, again, like Nichole said, it's hard to get actual costs for that. That's not to say it never happens. There can be circumstances, and if you can show that it was this epidemic directly caused certain costs, we could be in a circumstance where that sort of thing would be allowable. And I would talk to the government, your contracting officer, if something looks like it's going to happen to you, actually happen, not just like prophylactic measures that you're taking. Do that. Talk to the contracting officer, get out in front of it as much as possible to keep sort of these things from coming up on the fly, and then you being unaware that you're not going to get certain costs.
Yeah. So we've gotten a bunch of questions about the sick leave and the family leave, and I'm going to answer a couple of them. Again, there are a lot of you on the call or on the webinar today, so if we don't get to them all, we will try our best to follow up or provide resources. Essentially, one of the questions is, what if we don't qualify under FMLA now because we're not 50 employees within 75 miles? This amends FMLA to include you for these specific provisions if you're less than 500 employees. However, if you are less than 50, you might get some sort of exemption to it if you can show that you would really go bankrupt. You know, it's probably going to be difficult to show that for the 80 hours of sick leave the way they've capped that, although it may, you know, I don't know your business, it might, right? But I think if you had a substantial number of employees who might have to take the FMLA to care for children at home, and again, this only applies to employees who can't work from home too. So if you have employees that could otherwise work from home, you know, this might not be as much of an issue for you. We don't really know how it would apply to intermittent FMLA. So let's just say that you have an employee that could work part-time from home because they have kids at home, but maybe can't work full-time, and you have scheduling limitations on when people can work and when they can't work. You know, there might be some intermittent FMLA issues there. So again, we are also going to have to wait a little bit. After this thing gets passed, we're going to have to wait a week or so to get guidance from Department of Labor to see how stringent they are going to be on some of these requirements, and take everything on a case-by-case basis. For employers that are less than 25 employees, you might, there is indications that you would get some exemption from the civil penalties under FMLA. Meaning that if somebody went out and complained that you didn't do it right or didn't give them the leave, DOL could come in and make it right, but you wouldn't necessarily be subject to a civil lawsuit. Again, we're waiting to see some of those details get fleshed out. So there might be some padding a little bit for smaller employers, but it's pretty rough and tumble for anybody under 500 employees. The sick leave applies to everyone. Doesn't matter how many employees you have.
Just a quick alert that we're getting from our GoToWebinar provider. They're seeing unprecedented customer traffic. There are a lot of you out there and a lot of you asking questions. If you're having trouble accessing what we're saying or hearing what we're saying, bear with us. We're doing the best we can. There's obviously a lot of people listening to this webinar, and as I mentioned earlier, we will follow up this webinar answering any questions, or as many questions as possible. Documents will be posted to our resource center on our website, PilieroMazza.com. And to the extent you have specific questions, you can reach out to us individually, and we will answer as many questions as we can. We understand that there are a lot of you listening, and we're getting a lot of questions as well. So we're doing the best we can, and we'll try to answer as many questions as possible. So going back to a question that I have. So when an employee does test positive, and let's say they've been in the office potentially exposing other people, we just got a question, how does HIPAA come into play there?
So yeah, so obviously we want to be really sensitive about other people's medical information. We always want to be sensitive about that. I would highly recommend you put out your protocol in some sort of policy memo, that it could include amendments to a lot of your different policies. For example, do you need to make amendments to your telework policy? Do you need to make amendments to your leave policy in short term? And I would tell people, look, we want you to tell us if you have symptoms, even if you don't know for sure that it's COVID. Like, we need to know to stop the spread. But then you need to make sure that it's going to your specifically designated person, and that you're never disclosing that person's name. This would be treated just like any other communicable health condition on a work site. You're not going to say, okay, well, Janie in finance has COVID, so run for the hills, finance, right? You're going to tell everybody that could be in the affected area that there is somebody that may have been in contact with COVID, and that we want everyone to take proper precautions, and that's just a safety measure, right? But that doesn't mean we release somebody's name or any personally identifiable information. And if you are in a situation where it would be really obvious who that person is, you might want to talk about how to tactfully do that, or ways that you can mitigate any of that risk. Obviously, if, Janie in finance is running around telling everybody that she might have been affected by COVID, that's not going, that doesn't necessarily mean you can do the same thing, even if she's doing it, right? So those are things to be aware of. And then any medical information that you get, if a lot of employers are asking employees that have signs to go home, self-quarantine for the recommended amount of time. It was 14 days. I'm hearing some whispers that some physicians are saying 18 at this point. And that they have to show that they can safely return to work, at the end of that period. Some people are saying, I just have allergies. This is like one of those terrible time of year. Everybody's got allergies, colds, flus, all of the symptoms are very similar. But you can go and get even some sort of remote, teledoc type of clearance that says, you're okay to come back to work, without necessarily having that employee disclose their diagnosis. What's important is that somebody says that whatever symptoms they're experiencing are not communicable, not necessarily the condition itself.
So we're getting a couple of questions about, can employers send employees home if they appear sick, or they maybe even if they don't appear sick, but they've said something. For instance, in Washington, D.C., the first known case arose out of a church in Georgetown, and a client of mine called and said, I have an employee who goes to that church and took communion from this pastor. What should I do?
Yes, you can absolutely send people home if they're exhibiting symptoms. And that's another reason why you should be publishing to folks your protocol. These are not decisions you want to make in the heat of the moment. These are decisions you want to have thought about with the team that is responsible for thinking about these issues in advance, and communicating with employees about the expectations that if you come to work and you're exhibiting symptoms, one, you don't want people to come to work that are exhibiting any type of symptoms, and you make sure that they understand that that's something you really believe. And then two, if somebody does come to work, you can immediately send them home and say, look, if it's your allergies or whatever, then teledoc your physician, get the clearance and you can come back to work. But I have a whole workforce I have to worry about here. Now you cannot take people's temperatures. I have these questions. Can I take people's temperatures when they come to work? No, you may not. You can send people home. Those are types of privacy concerns that are overly invasive. And so you need to watch out to going that far. It's too far.
And sort of piggybacking on that, I would also recommend that you not try and counsel your employees about what the symptoms of COVID-19 are. You don't want to be speaking in the place of a medical provider. You can certainly direct them to publicly available information that has been vetted by a medical professional. There's a lot of that available on the internet. There's a lot available from the CDC. Generally, you should direct them to the CDC website and the CDC publications about it, rather than someone who you're not quite sure about their credentials, their ability to speak with authority on the matter. But generally speaking, you should not step into the shoes of a healthcare provider for one of your employees. You shouldn't be making the call about whether they have COVID-19 or whether they've been exposed, other than for the sole purpose of protecting your own workforce and making sure that there's no spread in the event that someone has been potentially exposed or is showing symptoms that you believe are sufficient to raise a red flag for you that you need to send them home, like we just discussed. But generally speaking, don't stand in the shoes of a medical professional. Even if you are a medical professional, some of our government contractor clients work in healthcare, obviously. We suggest that you do not take that role because that opens the door to liability in many other ways.
Just to reiterate too, when you're talking about a government contract and you're looking for a delay or to claim act of God, force majeure, it needs to be the coronavirus, right? It needs to be COVID. It needs to be this particular coronavirus, right? COVID-19. And if it's not, if you can't prove that, then you could have potential issues. The other thing is when you're talking about raising that sort of defense to a termination or to say, look, we get excusable delay here, you need to also show that you've tried to mitigate things. It's especially true if you have like an idle labor clause, and you're trying to say, look, I couldn't just shut down my whole business, but we couldn't really go to work anymore. So I have all my personnel on standby. A few things there. One, they have to actually be on standby. If you can get them to actually go to a location. Now, in this context, that doesn't make a lot of sense. I understand that. But the way the law is structured is if they're just sitting at home doing other things that are personal in nature and not sitting there on pins and needles, ready to go at a moment's notice, that can be a defense from the government to any sort of idle labor claim. Also, if you aren't taking proper precautions, and this is where the law is almost conflicting, where it's telling you you have to do what you promised under the contract. Yet at the same time, if you get a bunch of people together and they all get sick, the government could come around and say, you didn't take reasonable measures to mitigate the impact of this epidemic on you. And so therefore, your failure to mitigate the impacts of this could impact your ability to make a successful delay claim, excusable delay claim. So you're sort of caught in the middle there. And I would say, again, to the extent people can telework or get the job done in other ways, if you are in an area where people don't have to work in close proximity, keep people 10 feet apart, things of that nature, where if there's protective gear, not that it's necessarily effective, but these sorts of things that you're doing, you can show if you ever get to the stage of having to make a claim that no, I took all commercially reasonable precautions here, and it still happened to me, and I have proof that it was COVID-19. So that's the kind of thing to think about now as you're going through it, just from the GovCon perspective.
So what about, I've gotten a lot of calls this week about clients who have personnel in SCIFs and places where people basically have to be on site. And the concern is that the government is going to shut down those locations at some point, if they haven't already in some situations. And then what happens? Do they have to lay off their workforce? Do they, and I can talk about some of the employment implications, but some of the questions I'm getting are, can I just lay all of these people off? Will the government pay for me to have them basically sitting on the sidelines? These are people that are not easy to hire back if they go off and find other jobs.
Yeah, so this is very fact specific. This goes to the idle labor issue. Now, first, for the SCIF, my understanding of what a lot of government people are doing is, and my wife works for the Navy, so what they're doing in particular is limiting the amount of people that can be in the SCIF at any given time. They're also doing much more controlled cleaning of the SCIF, because I know some of these places, there's a computer for the whole office that has like TS material on it, and everyone's using the same computer, and so they have wipes and have cleaning and everything that they're trying to do, which how effective it is what it is, but they're taking those reasonable precautions. Now, if you have, the question is, okay, well, let's say they shut the whole SCIF down. What do I do with my folks? Do I lay everyone off or what? Well, if the individuals are highly specialized, and this is a point of fact that would have to be proven if the government gives you a hard time, makes you go through a claim and an appeal, you're going to have to prove that these people are not easily replaceable. And just having a clearance, depending on where you are, I guess, if you needed cleared people up in the north of Alaska where there's literally nothing, then that might be easier to prove, right? Whereas if you're sitting in DC and you're saying, I need people that have clearances, I hear it all the time. I understand it's not easy to get those people, but it's also not impossible. And there comes a time where there's a line that's crossed where for 2 weeks, okay. For a month, maybe even okay. For 3 months, it starts to get harder to prove that you had to keep these people on staff. Now, again, though, it's fact specific. So if there's a particular individual, it's not just they have a clearance, a particular specialty of like a very unique individual. And I know people think everyone has unique individuals, but you got to think of this objectively. Like, not
lawyer words.
like, right. Like, just because this person really knows that their stuff, it has to be something very unique. Like, obviously, like a Stephen Hawking type, right? Who this person has this very unique skill set, and there's only 5 of them in the country. Okay, that kind of thing you'd have an easier time proving, and then everything else is sort of in the gray. But again, talk to your contracting officer, right?
See if there are things you could do. The other thing that'll be interesting is with the sick and family leave stuff, because FMLA, for those people that have to be at home with kids, if you can't, gotta take care of your kids, so you can't be in the skiff, and the government's mad because you can't be in the skiff, right? Like the work's not getting done. What do I do about that, particularly when like this person might not be easily replaceable? You can't always just, if they qualify for FMLA, you're not going to be able to terminate them because that's job protected leave and they're entitled to get their job back. And it's a very restrictive statute. So you are, signing yourself up for a FMLA claim if, even if the government says get rid of them, hire somebody else, I can't do this for 10 weeks. You really have to push back on the government. And these are very difficult, very fact specific situations, but because of the high likelihood of a claim, you really want to be talking to somebody about these types of situations when they come up, because the FMLA and the sick leave are going to be job protected leaves. And so you might have, we have to flesh this out as we go, but we might have some sort of arguments on some of the claims that we couldn't just lay people off. It would be illegal to lay people off. So at least for a certain period of time, there might be some argument there. It has not been tested, but.
Right. Or backfilling. You might be required to do backfilling, and that's going to be increased costs that you might not be able to recover unless maybe if you could show, and this again is somewhat unprecedented, but maybe you could show that the person was out because their kid actually had the coronavirus. It was because of the epidemic. And I think maybe you could try to make some arguments, and again, this is unprecedented, there's no case law on this, but make the argument that schools are shut down because of this epidemic, which fits under the force majeure clause, and try to squirrel. I can guarantee you in the next year or two, there's going to be a bunch of cases going through the board and the Court of Federal Claims and other courts, frankly, that are all going to be, this is all going to be borne out. And so some of it, no one knows yet.
Right. I do want to touch briefly on generally what a force majeure clause is, what an act of God claim is, and when it applies, because frankly, as Cy mentioned, we are in a bit of uncharted territory. Force majeure clauses and act of God clauses are very strictly construed by courts, including the Court of Federal Claims and the boards of contract appeals. So if you have a force majeure clause that is very broad and says something along the lines of performance is excused on any unforeseeable event that endangers performance, that's probably not going to cut it. And this is going to impact more commercial contracts as opposed to federal government contracts, because you're typically going to get a more standard or form force majeure clause in a federal government contract, at least agency to agency. But realistically, your force majeure or act of God provision needs to very expressly cover the basis for invoking the force majeure. So it would need to say something along the lines of a health epidemic, a forced closure of the government, or a forced closure of businesses, something along those lines. So if you're drafting contracts now, one of the important things is now it's foreseeable that your business might be shut down for portions of time, or performance might be endangered because of this epidemic, or for future epidemics that may arise, just because the next 5-6 months might be in flux over COVID-19. It could go away and then come back in the future. So this is now something that you can foresee potentially being an issue in the future. You want to go back to all of your subcontracts, your prime contracts, federal government subcontracts, commercial business contracts, and you want to revise your force majeure clauses. And if you don't have them in your contracts, you want to put them in. That would be a good rule of thumb anyway. But now you want to make sure that you're tightening up the language, making sure that you're not using broad brush strokes, because you want to make sure that no matter what, something that might actually come up is actually covered in those provisions. Because in many cases, again, we've never had something like this happen before, at least not in recent history. And so there's not very much instructive case law telling us how courts are going to react. And each state has generally they all follow the same guideposts, but they all have slightly different interpretations of how to enforce a force majeure clause. So you want to be very careful. The better business practice is to have a very specific and yet very broad, where you're putting very specific provisions in the force majeure clause to protect you as much as possible. For additional resources on force majeure clauses, our colleague John Williams actually yesterday participated in a webinar that was specifically related to force majeure clauses. I believe that is already available on the PilieroMazza website, but it may be available coming up shortly. I would encourage you all to listen to the recording of that webinar. It was very helpful in understanding where the reality of insurance professionals are thinking about general liability insurance in case there are lawsuits that arise out of non-performance of contracts, and the legal perspective. So I would encourage you all to listen to that as well as today's.
And another note from the GovCon angle is that the force majeure idea, or in getting therefore an excusable delay in your contract, doesn't mean that the government has to keep your contract in place. So, and there actually are cases back from the late 1800s and early 1900s where the government terminated contracts for convenience and moved to a different contractor who wasn't suffering the same problems. And the T per C clause that the government can exercise is extremely broad. And that sort of termination is not wrongful. It's not improper for them to terminate you because all of your people are sick and they need to go to someone whose people are not sick. So be aware of that. And that goes to the backfilling, that goes to the idle labor, all of that stuff. So at some point, the government might just find someone else. So again, communicate, see what you can do. If you can talk to the government about, look, they really like you as a contractor, you're doing a great job, and maybe giving you some extra money to keep you on board if they really like you. But you just need to be aware that the government could take more drastic action. That's always a risk.
So in addition to force majeure clauses, I think it's important to talk a little bit about just general potential liability that can arise out of the circumstances. We've obviously touched a little bit on wage and hour and sick leave issues that you've got 88 potential issues that come up as well. Americans with Disability Act, Family Medical Leave Act, Fair Labor Standards Act is wage and hour and overtime, requires a federal minimum wage, things like that. All of those are potential issues. Breach of contract claims based on non-performance or delayed performance or inadequate performance are all possible. You definitely want to start taking a look now before the issues come up at your insurance policies. You want to make sure, I mean, to an extent, it may be too late to have insurance coverage for things that have happened in the past. But if you foresee the potential for an inability to perform over the next couple of months, you may want to double check your insurance policies. Make sure you know what is covered and what is not covered. Talk to a lawyer about what is covered and what is not covered based on your specific policy, because you want to make sure that you are watching your own bottom line down the road when the inevitable problem hits. Because what do we have? I mean, we're having a significant impact on the economy right now. The Dow Jones has fallen significantly over the last couple of weeks. We're in.
Just try not to think about it.
Yeah, no one check your 401k
Yeah.
balances. But the reality of that is more far-reaching than our own bank accounts, right? So people who rely on or live paycheck to paycheck, people who are performing hourly work, when they don't have work to do, when they're not receiving their pay, if they're laid off or put on temporary leave, or if they're on sick leave, or even if they have to go on workers' compensation and somehow get covered, they're getting less pay than they anticipate. And what happens when that occurs? You get a lot more employment litigation. It's just the cycle. It's a vicious cycle. When people are pulled off the workforce, the reality is that lawsuits go up. When the economy crashes, and maybe it's not crashing, but it's doing something pretty bad right now, litigation increases. It is much more difficult to work out a negotiated resolution of a dispute with another business when the economy is bad, because both parties are trying to maximize the amount of money they can get to protect their bottom line. So before you get into any fights with employees, other parties, I can't stress enough how important it is to document everything that's going on. So when you have a slowdown because you've got 15 employees out of the office and maybe you're going to miss a deliverable, you need to record the number of employees that are out, the real life impact on the contract when those employees are out. You don't need to name their names, but obviously for your own documentation, knowing how many employees you have out so you cannot meet obligations. You need to document how you're trying to mitigate that work. So for instance, if you've lost half your workforce and you ask the remaining half of your workforce to work 10 hours of overtime in a week, make sure you're documenting that so that you know the additional costs that you've incurred, because those can all help in defense of litigation down the road.
And call whoever your trusted advisor is, and we work with a lot of you, but again, this stuff is all fact specific. I know some of you have asked questions about, well, this state might be offering extended unemployment benefits, and this state might be offering, can we dip into some of that instead of paying the sick leave, or can we, all of that is going to be fact specific, and we are constantly, my team in labor and employment has their eyes radared on these questions right now as to how all of these laws are going to interact with each other. How's this new sick leave law going to act with the, executive order on sick leave for federal contractors that many of you have? Those are answers that when the bill is finally published and the DOL regulations are issued, we will be, pushing out information to you as much as we can. But before you lay everybody off that has a kid at home, let's talk, right? Because we don't want anybody to end up with, as Matt said, an increased risk of litigation when there's something we could have avoided. Even if you have a poor performer you've been trying to get rid of for a long time, there's an increased risk of that. So what about HubZone, folks? What do they have to worry about?
We had some questions. So there were some questions about HubZone and whether or not, if a bunch of people are go out or you have to take them off your payroll, and does that impact your HubZone status? And if they're not on your payroll and you have contracts ongoing, the rule is not that you have to meet that 35% rule the entire time. The rule is that you have to get best efforts to keep that up. So that shouldn't be too much of an issue. Where it's going to become an issue is the time you bid work. Because the time you submit that proposal, you have to meet the 35% rule. And if you're at 34%, you don't qualify. You're not an eligible company. And the way, if you get protested, the SBA is going to look at that is the prior 2 weeks, and they really look at the prior month to get that 40 hours per month down. So if you took people off the payroll because of it, and now you're falling below, you shouldn't be bidding new hub zone work. That's where it's going to impact you, as opposed to continuing to do hub zone work.
Right. And let me just touch on sort of collateral damage for bidding on hub zone work, for instance, or some other contract where you, maybe it's a set aside where you don't meet the requirements as a result of this epidemic. That could create, let's ignore the fact that someone files a protest. Let's say that it's not filed. If DOJ or the agency you're working for finds out later that you were not qualified at the time you submitted your proposal under the hub zone program, even if you potentially come into compliance later on, that could present False Claims Act liability down the road. False Claims Act liability often increases at times of national crisis. In fact, the False Claims Act was created based out of wartime, because what ends up happening during times of crisis is companies, whether it's in good faith or bad faith, try to cut corners to protect their bottom line, and they drop on things like compliance. They don't have as many people checking on those numbers, or they have people who are somewhat inexperienced checking on those numbers. They are far more worried about what's going on with their employees than they are with making sure the T's are crossed and the I's are dotted with regard to, for instance, the number of people in a principal office for a hub zone contract. So now is not the time to get distracted by all of the other things and leave compliance with your federal government set aside programs for a later date. You want to make sure that you're paying attention to all of the same things that you would be paying attention to on a day-to-day basis to ensure compliance with the programs. Because again, I mean, I keep saying this, the last thing you want is for litigation to rise down the road and you're not prepared. So when you're when you're submitting proposals, you want to make sure that you are double and triple checking compliance before submitting. Obviously, if you qualify as a hub zone, we're not telling you not to bid on hub zone contracts that become available. Frankly, the government may extend, various agencies may extend the deadline for submitting proposals during this period of time anyway, but you want to make sure that you're following up on compliance, because the COVID-19 epidemic could have far-reaching implications long after it has sort of become a lesser issue as far as public health is concerned.
I saw a couple of questions too about what if I have a number of hours that I have to provide in my contract, or it says certain number of FTEs, certain number of hours, certain number of widgets I have to produce, and then all of a sudden everyone gets COVID-19. If you can prove, again, this goes back to, if you can prove it's COVID-19 and not something else, then there could be a claim for excusing of some of these things, or excusable delay, and say, look, we couldn't get this work done. However, that extends the contract. Even if it's a firm fixed price contract, if it says a certain number of widgets or a certain number of hours, the government has agreed to pay that firm fixed price for those number of hours or those number of widgets. And so if you are not producing those, you are technically in default of the contract. And the force majeure excusable delay allows you to get out of that situation, potentially, of a termination for default, but it doesn't let you just continue billing even though you're not doing the work. However, if it's a firm fixed price contract that just has a deliverable requirement, it's not particular hours or particular number of widgets, and you're still doing that work, you're still getting those deliverables done, or they're not due for 6 months from now, and even though your people aren't working at all right now, let's say, for example, and then they all work crazy hours in crunch time to get this thing out before it's due, you can bill for all of that time. So you just have to pay attention, or all of that work, it's not time. You should just be aware of what type of contract and the exact language in your contract and what it says. The other thing we get around the same lines is this idea of DPAS contracts, Defense Priorities and Allocation Systems contracts. If your contract is DPAS rated and you have a bunch of other contracts, or it meant each DPAS contract also has certain ratings inside of the DPAS system. So one can be rated DO, one can be rated DX. There are different sub ratings even under that. And so the higher ratings always have to get priority of your personnel and resources. And the question came up, well, what if I have a DPAS rated contract that's taking all of my people and I'm effectively defaulting on all my non-DPAS rated contracts? Well, the DPAS was created for situations like this. So you can't not do the DPAS rated work or the higher DPAS rated work. You need to make sure that you're allocating resources appropriately to get that work done. And then when you're on non-DPAS rated work, if it's suffering, if that performance is suffering, the law itself is generally structured so that the government, other agencies shouldn't be penalizing you, but you need to start talking to the contracting officers up front and let them know that this is impacting you. And if you can, backfill those other positions where you're shifting employees, hire temporary staff, hire new people, try to mitigate all of this to the maximum extent you can before you just throw your hands up and say, I can't do it any longer, because that's where people can run into a T for D problem.
Okay, so we're actually running out of time, and I think we're going to end up going a little bit over. Sorry for those of you who are on a tight deadline. I know we haven't reached all of your questions. I know that it's been a lot of information in a very short period of time. We would suggest that if you have specific questions that we didn't cover here, you reach out and to one of us. Sorry, I'm having a little trouble with the slide, but hopefully you can still see it. You can reach out to, yeah, we're good. You can reach out to one of us. I've put our contact information on the screen. You can also reach us, generally speaking, at 202-857-1000. You will likely get people's voicemail, but we can call you back pretty quickly. We here at PilieroMazza are taking COVID-19 very seriously, and so we have implemented mandatory telework where possible. So before we sign off, and then obviously apologies, I'm going to switch the slide. As I mentioned earlier, we're implementing an update to our website where we will launch a client resource center related to COVID-19, where we have answers to questions. We'll post as much information as we can so that our clients are up to date. But understanding that we haven't gotten to everybody's questions and we haven't touched on every single topic we possibly could have today, I'm hoping we can just close up with some key takeaways, some final thoughts on what we've talked about, some broad brush strokes. What are your bits of advice for the people who are listening and for anyone who downloads this in the future? Why don't we start with you, Nichole?
Sure. There is going to be a lot of movement legislatively on the state and federal level in the coming weeks. That's going to necessitate that your human resources or other teams be ready to figure out how those pieces of legislation will impact your workforce and impact your current policies. And you're going to need to constantly communicate with your workforce and let them know how you are going to be implementing those pieces of legislation that will, be flowing through you. Some will go directly to them. So you will want to have, slow down, think about the what ifs, so that you have a plan of action should those things occur and have a good communication plan. My other piece of advice is understand that every situation is individual. And so if you have specific employee concerns or you think you might have to terminate or lay people off, talk to a trusted advisor so that you can stay out of a litigation situation down the road. And we're all navigating this together. And so use the resources that are available to you.
Right. As a litigator, my 2 cents on the matter is something I've mentioned a few times. It's documentation. 9 times out of 10, a case comes onto my desk and the employer or the company that is embroiled in this litigation has the best of intentions and the worst of documentation. And so a lot of what they're describing for me and how to defend a case is based on their own memory. And what I always tell my client is, you know, you're not telling me what actually happened. You're telling me what you remember. And you have a lot of things going on in your life. You have a lot of things going on in your business, and you have a lot of moving parts to deal with. So if you are keeping notes and keeping documentation and keeping it in a single place, usually, or two places, one electronic, one in hard copy, so that you can provide this information to anyone who might need it in the future, whether that's a lawyer or whether that's an auditor from DOL or from an OIG's office or any other agency which might just have questions about how you handled a situation. You've got that information close at hand, and you can provide it in a quick and timely manner. That's going to go a long way to solving any liability issues that come up because of this epidemic. And Cy, why don't you bring us home?
I would say communication. When it comes to the government, the number one thing that I always hear back, and when we get involved in any sort of government contract dispute or claim, is like, well, why didn't you talk to us? And then they come back and they show all the how there were crickets, no correspondence for months on end while things got worse and worse. So I would say get out in front of it. Don't, if things are really impacting you, yes, could they terminate you for convenience? It could happen, but it's worse, right? It's worse if you don't say anything, and then all of a sudden you're like, hey, by the way, my entire staff is out and they all have COVID and they're all short up somewhere. So just make sure that you're talking to the contracting officer, because I would like to think, and we have former government lawyers who are on staff here with us and have advised COs for years, and I talked to them and they were just like, well, they would like to think that people would be reasonable. And this is uncharted territory. I know that might be a lot to ask sometimes, but communicate.
All right. Thank you, everybody, for your time and for listening, for dialing in. This is one of our larger webcasts. We have our webinars. We have a lot of people still signed in. Again, we are going to publish on our resource center resources for our clients and anyone else who has access, who can access those materials. We didn't get to a lot of your questions today. Feel free to reach out to us. We will continue to update the website, and if it becomes apparent that we need to do this again to touch on some more issues, we will do that. If this has been helpful, certainly leave us a message in the box before you sign off. If there are topics that you would recommend that we talk about in the future, do that as well. Other than that, we wish everyone the best of luck moving forward. This is a difficult time for everybody. We understand that. We're here to help if necessary. Again, we've not been providing specific legal advice for you or your company. We're just talking about the generalities today. So if you have specific questions about your business or the impact of this epidemic on your bottom line, we recommend that you give one of us a call, or Catherine Hickey in our corporate and mergers and acquisitions department or practice group. She's not on today's webinar, but she is a smart cookie and willing to answer all of your questions. With that, I think we'll sign off. Thank you to everyone for listening, and we hope you have a great rest of the day.
Stay safe, everyone.